a recent email. Meeting is now streaming live. Okay, there we go. Never mind.
And I'll count to 5, right? Good evening. My name is Maureen Lemassey, and I want to welcome you to this meeting of the Police Reform Work Group. We're sorry for the delay. We had a little bit of a technical issue. I welcome not only our members, but also the public who are watching these proceedings. If you are joining us for the first time, our mission is to provide our County Executive, Angela Alsobrooks, with substantive recommendations that will establish fair practices across the board and restore public trust in law enforcement. We have established 5 subcommittees that are beginning to meet. Our agenda tonight consists of presentations from the Office of Law, the Citizen Complaint Oversight Panel, and the Office of the Inspector General. Delegate Washington.
Thank you, Madam Co-Chair, Judge Lemassey. Thank you for the opportunity. And I just want to take a point of personal privilege to first recognize the officers who were shot last week. On August 25th, Officer Brandon Westfall and Officer M. Scott and Sergeant Johnson. And we're glad that they're all recovering from their wounds and things that have happened to them. But I would be remiss if I didn't recognize Mr. Jacob Blake in Wisconsin and the situation that happened there of the young man being shot 7 times in the back. While his kids were while his kids were in the car, seeing this happen and seeing him gunned down in his car. As a Black man in America, this pains me, this hurts me to see this and to see this happen constantly. And it pains me and hurt me to see that our officers are being shot and killed as well. And so, I hope that this renews a sense of purpose to every member on this work group. That we have the ability to make some significant changes in our county police department and in public safety in general, and to ensure that we all are making sure that we have innovative recommendations that we can put forth to our county executive to really transform and be a beacon for other police departments within the country. So I'm looking forward to our recommendations, and as all our work groups are working really hard and diligently and starting to meet this week, I hope that you all keep that in your mind. Our county is no different from many of these other places. I hope that our county is looking at racial equity, because this is more than just policing. This movement is about racial equity throughout our entire county, throughout the entire country, and as well as in our county. So I hope that we are really working hard along with the county council, the county executive, the state delegation, and the state of Maryland. We all are responsible for ensuring that everybody feels comfortable in their skin, no matter where they are or live in the state and in this county. So with that said, we do have a really good presentations today. And so our first presenter, we're gonna ask Ms. Rhonda Weaver of the Office of the Attorney within the county. To help present today. We look forward to this great discussion. Thank you.
Thank you very much. Can you hear me?
Yes.
Yes, ma'am.
Thank you very much. And to the members of this work group, as well as the public, thank you for this opportunity to present. And I'm going to jump into it because I know you have a lot on your agenda today. So I'm going to go past the first slide. So can we go to slide 2? And Lieutenant Harvin, just tell me when you're there, because I'm looking at my slide.
So Ms. Weaver, she's there, but if you
okay,
the presentation is up on your, we all can see it clearly. If you go to the Zoom account, it's up, and right now she's on the Office of Law Responsibilities and starting with the mission statement.
Right. Okay, that's right. I looked at it, so she was. I'm using a different set because I have some little cheat sheet notes. So, but again, I wanted to start with. I was told to kind of explain, the role of the Office of Law, as well as the county attorney's role, and just very briefly. The Office of Law provides legal services to the county executive, the county council, county agencies, county employees who are acting within the scope of their employment, and boards and commissions to help ensure that the county government is operating in a lawful manner. Next slide. As far as the county attorney oversees all operations of the Office of Law, and by charter, they serve as the legal advisor to the county executive, county council, unless the council specifically directs otherwise, and to county agencies. The county attorney is assisted by deputy county attorneys and associate county attorneys. One note I wanted to make, particularly because we have the public listening today, is that sometimes the people confuse the Office of Law with the state's attorney's office. And that's because the Office of Law is also commonly referred to as the county attorney's office. Okay, the county attorney is appointed by the county executive and subject to approval by the county council. On the other hand, the state's attorney office is headed by the state's attorney who is an elected official, and they are charged with the prosecution of crimes. The Office of Law handles all civil matters. We do not handle criminal matters. Next slide. As far as the police department goes, the county police department is one of the many agencies to which the Office of Law provides legal services. This includes responding to subpoenas and other information requests. There is one associate county attorney who is detailed full-time to the police department, and that is John Mitchell, who's also on the call with us today. And he, more of his day-to-day functions probably deal with some of the questions we're going to have today. So I ask for, and I thank you all for granting him the opportunity to also be here with us to answer any questions. And while we do have Mr. Mitchell's assistance, there are other attorneys in the Office of Law that provide legal services to the police department. Next slide. So as I understood the subject matter for tonight, we want to talk about personnel records and specifically why the Office of Law often takes a position that personnel records for county employees are personnel records. And that's because both state and county law mandate that these records are confidential. Next slide. So let's first take a look at state law. And primarily we're talking about the Maryland Public Information Act. I'll probably refer to it as the MPIA as we go forward. Now, generally speaking, the MPIA allows all persons to have access to information about the affairs of government and the official acts of public officials and employees. So that is the general rule. That's the mandate, that's the legislative intent behind the MPIA. However, the MPIA also includes several exceptions, and included in these exceptions are required denials. So these are denials, these are requests that a custodian of record is required to deny. And among those required denials are personal records for county employees. Next slide. So what I have here on slide number 7 is basically just an excerpt from section 4311 of the Maryland Code, the General Provisions article. And basically it says, basically what I just said about the fact that personal information is confidential as a part of the required denials. We are not allowed to release those records. Now, actually, I'll come back to internal affairs files in a minute. But I also list here those persons who are allowed to inspect by law. And those include the person in interest. That means in this case, the employee, an elected official or an appointed official who supervises the work of the employee. And then there's a relevant article, well, not relevant probably for our purposes, but that applies under the education article. But I just gave the whole provision of the statutory provision here. Next slide. Another point I wanted to make is there are penalties and violations for not abiding by the MPIA. And basically those are sections and the general provisions, article section 4401 and 4402. And basically they provide that a person, and in this case, we're talking about, and a person includes an officer or employee of a governmental unit. If they knowingly violate the MPIA, the court may award actual damages as well as attorney's fees and litigation costs to a successful claimant. In addition to that, there is a criminal penalty, and a person could be is guilty of a misdemeanor, and on conviction, they're subject to a fine not exceeding $1,000. Okay, I want to make a note here that the Court of Appeals has issued opinions that personnel records include records that deal with the hiring, discipline, promotion, dismissal, or other matter involving the status of an employee. Okay, and that's in the Kerwin case, and I can make sure I get Lieutenant Harvey these citations afterwards if that's desired. And also there's a Shropshire case, and again, these are Court of Appeals cases, and where they found that internal affairs records that are specific to the employee, so basically they identify the employee, those are also considered personal records. So generally, if we get a subpoena or request from the public for personnel records, we have to cite these provisions of confidentiality as they relate. Now, we can get into a little bit more specific how sometimes, the courts through the discovery process or some other type of process can basically they'll issue an order and require us to turn over the information, and we receive that and we abide by that. But without that court order, or unless we have another exception, like the employee agreeing to the release of the information, the county attorney's office takes as other legal opinion that we cannot on our own release those records. Next slide. I also wanted to mention the Law Enforcement Officers Bill of Rights, because that has a relevant section. And as you can see here from the slide, a police officer that can basically ask for the expungement of a formal complaint that's been filed against them, if that complaint was investigated by their law enforcement agency, and the charges are either the officer is exonerated of all charges, or a determination is made that the charges are unsustained or unfounded. Now, generally in the police department, I believe they use the word non-sustained, but bottom line, it means that they could not tell, like they could not show by preponderance of the evidence that the officer committed the acts that are the subject of the charge. Okay, unfounded really means that they find that there is no merit to the allegations. Unfounded means they find that the allegations or the charges against the officer do not have merit. And then also, if a case is investigated and the charges are sustained, the officer can go to the hearing board. Okay, and the hearing board, if they dismiss the case, if they acquit the officer, or they do a finding of not guilty, the officer can ask for those files to be expunged. Okay, and there has been at least 3 years since the final disposition of the case by either in this case, the police department or the hearing board. Because what sometimes happens is, even from a hearing board, you might have some appeals. So it's not considered finally disposed until all hearing proceedings have concluded. And then finally on this point, the LEOBR states that evidence of formal complaints are not admissible in administrative or judicial hearings if basically the factors I just discussed are met. One, the officer was exonerated, the charges were not sustained, they were not were unfounded, or the hearing board has basically acquitted, dismissed, or found the officer not guilty. So that's all I have under state law. The next slide, we're going to move to provisions under the county law. Okay, so similar to the MPIA, under our county charter section 203, Basically, persons have a right to inspect any public record in the possession of the county government, okay? Again, though, this provision is subject to exceptions, and one of the exceptions we have under the county law are personnel records. Next slide. So under our county's personnel law is subtitle 16 of the county code. And section 16215 basically sets forth the fact that personnel records are confidential. Now I'm going to note here that the Title 10, Subtitle 6, that's still referred to in our county law, that has been recodified to the Maryland Public Information Act provisions I cited at the beginning. So that whole section has been recodified under the general provisions article of the state code, but the county's code still reflects the prior codified provisions. Substantively, if what you have under, of course, the general provisions is accurate, but our county code provision still reflects the state government article, but this is the MPIA. So again here, so it talks about there are unless you meet an exception that we'll get to in the next slide. That basically, unless you meet the exception or is otherwise allowed to be shared pursuant to a state or federal statute, then the information is confidential. Next slide. So again here, all I have here are the exceptions we have in the county law as far as who can have access to a personnel record. Okay, and this is section 16216D as in David. And again, the list is right here. So it's the employee, any person to whom the employee has given written authorization, the appointing authority or the supervisor of the employee. That means the director of the agency they work or their supervisor. The personnel board as may be needed to carry out their functions, the county auditor, the county director of finance, and the county equal employment officer for the purpose of investigating an appeal that's been referred to them by the personnel board. And then finally, I just note here that under section 16217 is really the same similar provisions, but they apply to departmental or agency personnel files. Because each department or agency can have a departmental personnel file, and then there's the central file that's maintained by the Office of Human Resources Management. And under the county's personnel law, there are also penalties for violations. And any person who's found to have violated a provision of this specific subtitle about the confidentiality of personnel files can be fined up to $1,000. Okay, and then the very last slide, I have my email address in case someone wants to get in touch with me. And then I am prepared to take any questions. And I think I made my time.
I think you did. I think you actually went a little bit slower than we, or quicker than we thought. Judge, let's go to you first. Do you have any questions?
No, not at this time.
Okay. Any questions from anyone else?
I might have one. Or
yes, Mr. Lottridge.
Good evening, Ms. Weaver. I just want to clarify. So 16216DH, which basically stated any person who is specifically authorized by law, would that be basically in your mind or in the Office of Law's minds be when the court orders it? Is that?
Yes, I mean, well, yes, anytime we get a court order, we abide.
Okay.
A lot of times, you know, so let me just give an example. And I'm gonna stay with civil litigation because that's what I do. I'm not a criminal litigator.
It's fine.
We might have a lawsuit where they may be asking for information that we believe to be relevant. I mean, we agree that is relevant, but because it may involve the personnel file of another employee, and by law, we can't disclose it, what we'll do is, you know, we'll either probably go to the court ourselves or we'll tell the other party, you know, we will issue this if you give us a court order, or if we can't come to an agreement, you know, if the court orders the disclosure, we give it. So yes, absolutely, a court order is what we need to make sure that the county is protected once that information is disclosed.
And right now, that's a mechanism by which IA records are generally received by anybody other than other authorized personnel, correct? Is through a court order. There's no other mechanism?
Not that I'm aware of, but if you don't mind, respectfully, I'm referring to Mr. Mitchell because he deals with this on a daily basis. I know in civil litigation, we don't give it, we give it with a court order. And generally,
Right.
the parties reach an agreement, we just have the court adopt it as a court order. Okay.
No, it's not a trick. I agree with you. I think that probably is the only way, and I'll let Mr. Mitchell chime in. I was just making sure there wasn't.
I was just checking myself too, so.
That's fine.
John?
Yeah, if there is discernible or Brady or impeachment information that the police department has in its possession, we'll get a request from the state's attorney's office to review the file. And if we have that information, we'll let them know about it. They'll obviously then let the defense know that there's an issue or there's something that we need to disclose. And then usually either under a subpoena or an agreement, we'll go to the judge and say, this is the information. We want to enter into a confidentiality agreement and then issue a court order, and we'll disclose the information.
Okay, but the mechanism is always by court order. There's no
By
other.
court order, and usually a non-disclosure agreement.
Right, unless the employee consents, of course.
Right.
All right, so how, I mean, I don't want to get in the weeds because there's a lot to unpack in that presentation. How often do we get court orders to get us records or to be disclosed to defense attorneys in cases?
Well, usually there's a three-step process.
Yeah, no,
And you're probably familiar with that.
I'm familiar with the process.
The second process is the in-camera review.
Right, how often?
Probably I've only maybe done 5 or 6 in-camera reviews in the past 2 years. There's not many files that, have impeachable information in them. So.
Is that because a lot of them get expunged, or?
No, they can't expunge sustained findings.
All right,
If
so,
someone's sustained findings for an impeachable, it's there forever.
well, they can't expunge it if it's not, yeah, I get that, or it's been less than 3 years.
Right.
So I mean, I guess what my point, and the point I'm getting at is, so you've been through 5 in-camera reviews in 2 years. There's about 25,000 jailable cases, actually more than that, in the county per year. It seems like there might be more impeachable evidence in the entirety of the police department than 5 cases in 2 years.
Well, we currently have a process that we just started with the state's attorney's office. We're looking back through all these records to make sure that the police department has identified any of this information.
But, and
we're trying to be diligent in identifying the officers that have issues.
So I guess that's the next thing, is to get to figure out what that process is for identifying so that there is this communication. Is that
correct?
All right. So that's on my tickler to get into next then, I guess. I'll let you know. I'm not trying to nail you down, John. I just wanted to make sure I understand what.
We're not gonna not disclose information. It should be disclosed.
And can I just add one thing that may be relevant?
We know about it because we started this review process.
Right. And can I just add one quick thing? John, correct me if I'm wrong. I believe that if it's a police shooting, we never expunge that file, correct?
Correct.
Investigation and police shooting, those will never get expunged.
Okay. Thank you.
Yeah, Mr. Mitchell, if you can get us that information that he asked for. I think he said that you did about 10 in-camera reviews. And can someone explain what an in-camera review is for the rest of us?
We present the file to the judge, and he goes back into his chamber, and he can do it by himself, or he can do it with the representatives there, and he reviews the file, and he makes a determination whether the file should be disclosed to the defendant or not. And if he says yes, then he'll issue the order and we'll disclose it. If he says no, it doesn't meet the criteria, then it ends there.
And you'll get the data points for us on that one.
What's that?
Or is it just 10? I think Mr. Longridge.
Well, it's set out through case law.
No, he was asking for like about how many cases. You mentioned how many cases you've been doing the last 2 years, John. I think you're asking like if we have any data around that, how many times that's happened. Is that correct?
Correct.
Yeah, I believe I said 5, I think.
So they just want you to check and confirm.
Correct. Thank you for that. Ms.
That
Morning.
might be a little.
Yes, good evening. Thank you, Ms. Weaver, for that presentation. I just have a couple of things for clarification. Excuse me. Did I understand you to say that there are actually 2 personnel files?
Yeah, there's usually a departmental file.
Mm-hmm.
There's usually a central file that's maintained by the Office of Human Resources Management. And for the most part, the file should probably, be the same, except that your departmental file going to have things like maybe schedules, maybe leave slips. They're going to have some information the central file will not have. Okay. But when it comes to things like, resumes, discipline, pay information, that should be in both files. I can tell you one thing that is probably not going to be in the Office Central in the Central Human Resources file. That'll be a counseling, because counseling's under our personnel law is not discipline. Okay, it's like the step before discipline. It's like to give the employee an opportunity to do better. So those generally are maintained only in the departmental file, and generally now. Let me back say, this is when I was in the Office of Human Resources Manager, and I believe that practices are the same. But so you really have more in a departmental file, like more of the day-to-day information, again, schedules, leave requests, things of that nature, than you're going to have in the central OHRM file. But the more substantive information should be in both files. So even when an employee leaves, the practice has been when the closeout is completed at the department level, that department file is sent to the central office, and the central office kind of makes sure, they have the same information minus those non-substantive matters I mentioned. And then basically the files are merged, and then at a certain point in time, the file goes to storage. That's why that is during the time we're in a paper file world. I don't know what it's going to look like when we can finally get to more electronic files, but that's how it pretty much works now.
Okay, so an officer that leaves the department, that leaves the police department and goes, say, to Wisconsin or whatever to get a job. So will information from that central file be shared with Wisconsin?
Be shared with who?
Hypothetically, if a police officer leaves this department here in Prince George's County, goes to Wisconsin and get a job as a police officer, will the central file information be shared with Wisconsin?
It depends on whether or not the officer signs a release. Because particularly if it's a public safety position, as part of the clearance, they have to sign releases as part of the background process. And generally that's a release that is a broad release that gives access, that says that tells us it's the written authorization that says, yes, we can give you this person's personnel information. Okay, that's generally how it works. In other situations, if they just give us a call and ask us about employment, Human Resources generally gives a very, they confirm the employment, the dates of employment, the position, the department, and they'll give salary. I should have mentioned too, that salary is not confidential, okay? Under MPIA for a government employee, the salary is never confidential, all right? But they'll give that information. To give more, we're going to need a release from the employee.
Okay, and like
the other exceptions apply.
And likewise, when we are hiring, then we would also reach out to, if it's an officer have had a job as a police officer in another state, we reach out also and ask for information. And we would have that officer sign a release?
Absolutely.
Okay.
So
Yes.
Let me clarify that, because that question was asked to PGPD when they were here. And so it's not law that they have to request it or have to have it. I think it's a practice that they have, that they request their personnel files. Is that correct, Ms. Weaver? That is not law, but they don't have to request their personnel records if they.
When you say they, you mean the
PGPD recruiter, the recruiter here in PGPD.
I don't know. They always request the file. I know here in the background unit of OHRM, because OHRM really does they lead the background investigations. And I'm trying to think back. I know they make contact. I know they ask about any, I'm gonna call it derogatory information. They actually interview the supervisors, and I think it depends on the information they receive. If they actually get a paper copy of the file, actual copy of the file, I can't recall for sure.
Yeah, got it. Yeah, it's just what I guess my point there is that Ms. Morning is not law that they have to request it, and it's not that, and they do request their personnel files, is what was told to us by the.
I remember that.
But they didn't. But it's not required. Let's go on to the next question, Ms. Morning. Okay. Yep. And so we're gonna ask Miss Joy to hop in here real quick, and then we're gonna end the questions with Mr. Lockridge and then myself, and unless the judge has a question. Ms. Joy?
Thank you, Delegate. I appreciate that. I have a quick question with regards to, your legal opinion on the confidentiality of the personnel record.
Yes.
I actually have two questions. My first one is, the state's attorney office had requested, more access to the personnel records so that we make sure that we meet our Brady obligations in our criminal cases. Do you have a legal opinion on whether or not our request for access to these records is equivalent to an MPIA request? Because a lot of the case law and the Maryland rules refer to MPIA requests. And, I don't believe that our request for access is equivalent to an MPIA request. We are requesting access to that information to make sure we're meeting our discovery obligation, and anything that is subsequently turned over to us is turned over to the defense under a court-signed non-disclosure agreement. So if you could tell me your opinion on that, that would be great.
Yes, I guess I don't think of it as technically as a formal MPIA request, but it is the MPIA law that deems it confidential. My understanding is that there is a process or a system set up between the police department and the state's attorney's office that provides the state's attorney's office with certain information, and the state's attorney's office picks up and decide whether or not something is discoverable, and if it is personnel information, then go to the judge and get a court order. That's my understanding. So Jack, please correct me if I'm wrong.
That's basically correct. We send they request the information, we send it to them to review, and any stuff that we agree on is impeachable, we'll disclose to them. And then, they'll tell the defense, basically, I would think this is how it works. Look, something that we want to give you, but we want to enter it into a non-disclosure court order agreement.
Thanks, Jack, and I appreciate that. And my last question is, my understanding, when I read LEOBR, LEOBR has a provision that allows for a law enforcement agency to maintain a list of officers that may have credibility issues and require disclosure on behalf of this for when we have to try our criminal cases. My understanding is that even though the LEOBR allows the police department to maintain such a list, that our police department doesn't. Is there a reason why, or is that something that you'd be open to doing?
Well, let me first ask Mitchell, is that the flag list I hear about?
Yeah, I believe so. I, as far as I know, the department does not have a list. It's been my recommendation that they don't create one, because it will be constantly in court trying to fight. She's trying to get the list. And I think if the state's attorney's office wants to create a list, that's. But right now, the police department does not have a officer flag list.
But they are providing information if there's a credibility issue with the officer.
We are, yes.
Correct. All right.
Ms. Joy, you have any other questions?
No, thank you so much for your time, guys.
No, thank you. And please stay on, and Ms. Weaver and Mr. Mitchell, we'll ask you all to stay on as well, because until the end, because we're gonna have some follow-up questions too. I had another question from Mr. Lockridge. You had a follow-up.
Yeah, I didn't want to make it too easy on anybody. in Baltimore, there's a process now. I was wondering if Ms. Weaver or Mr. Mitchell knows how they're getting around what they're describing as the requirement for a court order in Baltimore, because right now the process in Baltimore is one of, I wouldn't say it's an open room where people can go in and look at everything, but certainly it's much easier to get through than having a court order for any particular case. So do you know what the process they're using in Baltimore is to kind of allow for more transparency? And then my second question will be, because we don't have a flag list and because we know the number is so low, is it possible for us to get whatever the process is where you're identifying, providing impeachment material, we get the written policy of that process to review? The committee, I mean, because it is problematic, I think, to say that there are only 5 cases in the last 2 years where there had to be an in-camera review, given the number of officers and incidents in this county. So I'd just like to see if we could get that process.
Renee and I are still working on putting it down in writing.
Okay.
So,
I promise I'll follow up with her. I can do that.
yeah, matter of fact, I just emailed her yesterday. I says, we got to write a memorandum of understanding and I'm going to write all this down. So when we're not here anymore, people have, have a pathway of which to follow.
Do you have any idea what they're doing in Baltimore as far as?
Very familiar, very familiar.
And what is the legal mechanism? Yeah.
Excuse me?
The legal mechanism was what I was wondering.
Well, I just know that the state's attorney has access to the IA Pro documents. And when they do disclose them, it's under a confidentiality agreement.
Okay.
Let me follow up to that and just ask, why haven't we been able to do that in our county?
Technically, it's against county code to give them direct access.
Okay, so and that's because of that list of
The list of
Exactly.
yes, the list of exceptions.
And Baltimore City doesn't have a similar law to that.
They may, but I'm not sure.
Well, the MPIA, so the exceptions in the MPIA would apply to Baltimore City, which is a much shorter list than the county's list of exceptions. So, and I really don't know how that agreement came about, but I think the key word probably is agreement. Somehow they reached an agreement for it. And I really don't have any background more than that as far as the system in Baltimore City, I'm sorry. And I'll just say too, is I think that if there is a concern about, to change, in my opinion, to change our position that they're confidential, to me, that is a legislative change. We take the position we do because we think we're abiding by the law. I mean, I'm of the opinion that we are abiding by the law and we have to. So I think if there's going to be a change to that, it will have to be a legislative change.
Okay. Judge
Delegate, that's just what I was going to say. I mean, would you agree that if we amended the county charter to put the state's attorney down as one of the people who can access that, or change the Public Information Act also to include the state's attorney as one who can access that, that would solve the problem, correct?
Is that directed to me or Delegate Washington?
To you, ma'am.
Okay. I mean, I think it would. I mean, as far we wouldn't take the position anymore if the law was changed. And
Right.
I do think the legislative process, that'll make it available for all interested parties to present their positions, and the elected officials will make a decision. But so I do, if it was changed, and I also think if that happens, I will recommend it would have to change the state law, the county law, and also take a look at the LEOBR as well, because to make sure we don't have any conflicts, because we don't want to go through that, that process, and then we have another conflict and we got to decide, well, which law prevails. So I think you would have to do a full scale review of those laws, and then it'll go through the legislative process.
But without changing the state law, it seemed like the Baltimore City was able to accomplish the sharing of the personnel files without changing the state law. So I would think that for you, I know that you're saying the county law can be changed to meet that the request of the state's attorney, or even the request to have access to those files. So it seems like it could be done at the county level and not only at the state.
Well, that's what I was saying. If there's going to be a legislative change, it should happen at all those levels, the state and the county. So there's no inconsistency. You don't want to change the county law and then have an open legal question about what the state law says. You see what I'm saying? Because the state law still said the records are confidential.
Yeah, I understand what you're saying, but I'm saying that Baltimore City was able to get around that without having.
And I don't know how. I've heard that it was an agreement.
I think that's Mr. Lottridge's point, is like what law allowed them to get around the state law.
Right, and sir, and that I do not know.
Okay, thank you. And just for a couple of quick questions for you, just for the Office of Law's perspective.
Yes.
You say you represent the county and all personnel, all county law. You represent them as the county Office of Law, correct?
Yes.
And so can you and you also represent the Prince George's County Police Department, just so that we're clear, when there's lawsuits filed against them, right? Can you tell us how many outstanding lawsuits that are open right now in this for the Prince George's County Police Department?
I could if I go into my legal files database, which I can't really do right this second, but I can make sure I get that information to back to the board, either to Ms. Brewer or to the lieutenant, and I can get the information to you probably by, if not tomorrow, or Monday, because we do have stats. And as a matter of fact, it may be a little dated. We also report those stats, every year in the budget books.
Correct. So that's my other question too, about all those stats about the settlements that have occurred, how much they were, and we want all the data we possibly can get on any lawsuits that have occurred. We don't want to, and so we want that information. Can you provide us the last 5 to 10 years of court cases that have happened, types of lawsuits, the money that was spent on those lawsuits? We want all that data and information provided to us.
You want the last 10 years?
If you could, yeah, of course.
Okay, and this is police cases, correct?
Correct. And so then, thank you for that. And so
no problem. 10 years might take me a little bit past Monday, but I should be able to get it to you within a week.
Fair enough. That works. Thank you for that. I think my follow-up question to that is about just the flag list. You said that, Mr. Mitchell, you mentioned that the county should not have a flag list. Can you tell me what list the Prince George's County Police Department has that flags residents or community members?
You're on mute, Jack.
I don't know of any list like that.
Police department has
I'm saying there isn't one, but I don't know of any.
Police department has a gang list that is a gang registry that they have within them. You mentioned that they shouldn't have one because it can potentially be a lawsuit for them. Is it possible you can look into if having that gang list is also puts them at some type of legal disposition for the county as well?
Yeah, I don't think it does.
Okay, well, can you look into that for us, please? Because if there's no flag list for officers who are, and this flag list, I guess, is officers who are not adhering to, who have had too many infractions or things of that nature. So I wondered if we can have, if you could look into that issue for us, that'd be great. Okay. And I do ask, and I am going to ask Mr. Turner to hop in here because he's going to be a presenter later, but he does represent. Go ahead, sir.
Yeah, he might have more information on the gang list.
I know I'm going to talk later, but I just want to respond to this line of questioning regarding flag lists. First of all, there's no requirement that the police department keep a flagged officer list. And to be clear, a flagged officer list is kept in order to is a list of officers who have potential credibility issues. The state's attorney's office keeps that list. When I was a member of the state's attorney's office, we kept a flagged officer list. But I think it's important to understand that we receive the list of the names of the officers from the police department. So the police department, although it does not technically keep a list, it does provide the names of the officers who the state's attorney's office then puts on their flagged officer list. So if the police department were to keep a flagged officer list, it would be exactly the same as the state's attorney's office.
Okay. You had another comment earlier, Mr. Turner. Was that it? Was that the
There was another question, another comment, but that's okay. Gone way past that point. So,
Miss Weaver and Mr. Mitchell, if you
Yes.
can stick around for us, that'd be great. Just in
Yes,
case
sir.
other follow-up questions that might come up through the other presentations. So next we'll have Miss our member here, Miss Florence Felix Lawson, who from the CCOP, who's the chair of the CCOP, the Citizens Complaint Oversight Panel, and who will be conducting her presentation. Thank you.
Thank you, Delegate Washington, and good afternoon, everyone. A pleasure to be here and to represent the Citizen Complaint Oversight Panel. And I have with me Ms. Denise Hall, who is CCOP's administrative director, as well as Marva Jo Camp. Ms. Camp is CCOP's legal attorney. And so the first slide is just an overview of what CCOP does. CCOP is generally responsible for ensuring investigations of complaints against officers of Prince George's Police Department, fair, impartial, and thorough. Go to the next slide, please. So this is a little bit of our history, the evolution of the CCOP. So in the 1990s, there was an incident of police brutality, much like what we're seeing today. So it was created, the panel was created in 1990 in response to recommendations by a blue ribbon task force established by former County Executive Paris Glendenning in the late 80s. And again, in response to that incident of police brutality, and legislation started with CB 25/1990 and evolved. And the first legislation created the CCOP, providing for objective citizen participation in the overseeing of the complaints that are investigated by Internal Affairs, and the investigations regarding allegations of excessive force, harassment, and or abusive language. And a couple of years later, the legislation CB 44/1994 amended the terms of the panel members from 2 years to 4 years. And then in 2001, the legislation expanded the CCOP's powers. And I'm going to talk a little bit about that throughout the presentation, but that particular legislation, CB 59/2001, expanded CCOP's powers, giving it authority to conduct its own investigations and to issue subpoenas to the county council, and also expanded the scope of investigations review to include all complaints filed against a member of the police department for violation of any law or regulation, whether brought by a citizen, officer, or any source. And this was essentially all allegations. When CCOP was first created, there was a certain type of allegation that can be reviewed by CCOP. And so 11 years later, it evolved to that CCOP reviewed all of the allegations investigated by the Internal Affairs Department. So we can go to the next slide. And so this is just an org chart. And this is organizationally, the County Executive Angela Alsobrooks designates the DCAO, Mark McGaw, for public safety, who oversees the CCOP. And you'll see Marva Jo Camp is CCOP's attorney. And as I said before, Ms. Denise Hall is the administrative director, and she has staff actually small. CCOP is very small office. And then we also have the chair, that's myself currently. And then we have panel members. And we'll talk in the next slide, we will go over, actually it's not the next slide, the composition of the panel, but we'll eventually get there. So now the panel authority, that is to review investigation of complaints against officers. That's what I said over in the general overview. And so it's important to note that the CCOP's authority does not extend to park police, state and municipal police forces, or the sheriff's department, even though in some of our reviews, there can be some intersection or involvement of those other municipalities, but we only have jurisdiction over allegations and complaints against the Prince George police officer. And the panel also can make recommendations regarding policy changes, supervision, operational procedures, training, and recruitment. And we'll go to the next slide. And the panel can participate in police accountability, outreach, and information dissemination, can conduct concurrent, and this is important, that we have the authority, but we can conduct concurrent and subsequent investigations and issue subpoenas to the county council, but there's a big but. CCOP has neither conducted investigations nor issued subpoenas due to lack of funding. So this is an authority that we have, but we have never used because of the lack of resources. And also the CCOP issues an annual report to the public, which is posted on the CCOP website and available at any time. So we will go down to the next slide. And so here we'll talk a little bit about the panel's composition. There are 7 members appointed by the county executive and confirmed by county council. And the panel members must be county residents, broadly representative of the county, cannot be current employees or elected officials of any non-federal jurisdiction, candidate for an office or employed by any law enforcement organization. And just procedurally, the county executive designates the chair, and then the panel itself selects the vice chair. Okay. And then I'll go into more specifically the current panel members we have. So it's myself, my name is Florence Felix Lawson, and I'm sorry if I didn't say that at the beginning of the presentation. Florence Felix Lawson, the chair of the CCOP. Kimberly Richardson is my vice chair. And then we also have Cardell Montague, Kelvin Duvall, Marsha Ridley, Daniel Vergamini, and a vacancy. We have 1 vacancy on the panel, but it is a 7-member panel. Okay. And then next up, we have just a little bit of data, which you can find in the annual report. It's historical data about the numbers of investigations that CCOP reviewed in the past almost 2 decades. Since 2001, there were almost 3,000 investigations, more. This was for 2001 to 2017, but we've reviewed about 3,000 investigations, and we've reviewed about 10,000 allegations in that time, and that's because within one investigation there may be multiple allegations against one or multiple police officers. Okay. Then we'll go to the next slide. And so this is a little bit about what we do, like the standard of review. So internal affairs, they will conduct their investigation, they'll complete the investigation, and there'll be recommended dispositions. And so the panel will use the same standard as internal affairs, the preponderance of the evidence standard. And so this is not the court's beyond a reasonable doubt or clear and convincing evidence standard. It is a preponderance of the evidence. So is there, for the panel, for every case that we review, is there evidence sufficient to prove or disprove? So it's more likely than not that the allegation under review occurred and or was lawful. And so we'll get a little bit into the types of dispositions that we review. And again, these are recommendations referred by internal affairs for each allegation they investigate. And so we will either agree or disagree. And we also provide alternative dispositions, or sometimes in a review, we find that there was an allegation that was not presented to the internal affairs. And so we will actually present it to the chief, and we'll give our recommended disposition. And so per state law, the chief renders the final disposition, and but the chief should give equal weight to internal affairs and CCOP's recommendations. And so we have, and Ms. Weaver went over this in her presentation, there is a sustained, and that's when it was a preponderance of the evidence proved that the allegation violated departmental policy or procedure. So the violation did in fact occur. Non-sustained is when the evidence fails to prove or disprove the alleged act occurred. And that is different than, I'm going to skip down to unfounded. That is different than unfounded, where the evidence actually proved that the allegation did not occur, or the accused officer was not involved. So the distinction between the two is that the evidence for non-sustained can either couldn't prove or disprove, versus unfounded where the evidence was clear it did not happen or the officer wasn't involved. And then exonerated is when the evidence proved that the act did in fact occur, but it was justified, lawful and proper. Sometimes, like in cases where we see use of force, there was in fact force used, but the evidence shows that the force was justified. And then there are administrative closures. The police department has determined that the investigation should be closed due to an administrative issue, like the officer is no longer employed, the officer may have retired or left the force. So we'll go on to the next slide where we can get a little bit more into some general data. And this is, again, can be found in the annual report. So the CCOP, again, we do subsequent reviews of investigations completed by IAD. So we're at the back end of IAD's reviews. And so we come behind the internal affairs and we review what they've done. And you'll see here that there are several different allegations. And so you'll see 3 charts here. And you'll find there are varying allegations lodged against the police officers. And you'll see in 2019, there was use of language, use of force, procedural violations, harassment, firearm-related allegations, ethics allegations, criminal misconduct, and attention to duty, and then conduct-related as well. And then in the next chart in the middle, you'll see recommendations by allegation category, and those are the 4 types of dispositions: sustained, exonerated, non-sustained, and unfounded. And based on the color coding, you can see how often the CCOP agreed with the different findings. And in the last chart, you'll see the recommendations. And this is a comparative look at the recommendations from 2018 and 2019, exonerated in 2018 versus 2019, how many we found to have been exonerated, agreed to have been exonerated versus non-sustained, sustained, and unfounded. So I will go on to the next page. So this one is about the challenges for CCOP. And it's interesting that Ms. Weaver's presentation talked a little bit about what we call LEOBR, the Maryland Law Enforcement Officer Bill of Rights. And this is the Maryland Code, and that has stringent provisions that dictate how and when and under what circumstances complaints against officers can be investigated. And LEOBR has a direct impact on the role that CCOP can play in the processing, review, and dispositions of complaints, and a little bit about those limitations in LEOBR. For example, it impacts CCOP's authority to conduct its own investigation because in the law, it states that only a sworn officer or designee of the Attorney General can interrogate or investigate an officer. So this prevents the CCOP in participating in the questioning and exercising its investigative authority. So there's that inconsistency in the authority that it has, but with LEOBR's restrictions. And in another example, it also limits, the LEOBR limits CCOP's ability to investigate officers. And also, the panel is structured in a way where we have limited access to the officers because the interrogation, according to LEOBR, must or should preferably be conducted when the law enforcement officer is on duty. And so practically that is difficult for CCOP if it had the resources to participate in those investigations doing so. And I will say that, CCOP and the panel members participate on this panel on a part-time basis. CCOP members, and this is actually goes, is related to the last challenge. So about working remotely. So the last one, and I'll just skip to the last one before I go into the report. I'll finish up with the reporting on this slide, but currently investigative files, and we review paper files. It is a complete paper workload, and we review paper files, and we go into the CCOP office. We have been traditionally, we go about once a week, but because last year there wasn't a quorum And I'll say that in order for CCOP to review and make decisions on cases, we have to have a quorum. We have to have a majority of our members. And so if we have a quorum, we're in the office and we're reviewing, but we review physically. And this limits our ability to conduct meetings during inclement weather, lack of quorum, or even times like this, where there are building closures related to COVID-19 related issues. And so change does require coordination of budget, IT, security, legal, and HR policy reviews, which is ongoing right now. So we have not met since March, since the county shut down its buildings for safety reasons. But when reviewing those files, we have access to paper records, but we're limited in the records that we review. And so if there's anything missing, we have to send it back to the police department. And we do have time limits on when we need to make decisions on our cases. We have 30 days from when IA submits the case for our review, with a possible 10-day extension. And then the last challenge, and one of the bigger challenges that we have here, is the analytical reporting. So we have a data entry system that provides data useful for descriptive reports, and this is what we've used to create and provide information on the annual report, but it doesn't provide an analysis of the data. So for instance, if we wanted to, if we don't have the capacity to capture data about a particular officer and see if there are any particular trends, and even if an officer has some allegations lodged against him or her, and there's a series of non-sustained, we would find meaningful data to see how often complaints were lodged against a particular police officer and see the analysis of the types of allegations, if they were in a particular region, or if there's a particular region in the county that has a high percentage of particular dispositions like use of force. We don't have our data entry system does not provide us with the type of functionality to be able to do this analysis, but we are seeking options for obtaining these kinds of reports. And that is ongoing as well. And we will go on to the next slide. And this one, there's a lot of information here. The reports, as I said, on the left-hand side, the reports, annual reports are issued within 180 days after the end of a calendar year. So for 2019, our report went up sometime in July. We have some contact information at our offices in Largo, with some phone and contact information for our office. And for CCOP meetings, and this is directly related to the conversation about personnel records and the disclosure of those records and the confidentiality of those records. While general matters are subject to the Open Meetings Act, personnel matters are exempt. So CCOP does not typically deal with general matters and have not conducted open meetings, but we are developing a process for obtaining public feedback and comment. And we have the forms where any citizen can download, they can go to their public library, they can go to the police department themselves to file a complaint against any Prince George's County police officer. And the last one, we have not, CCOP has not engaged. In 2019, you'll see in the annual report that we weren't able to engage in a lot of community activities. And this is something we would, where we would like to change. We want to engage more with the community and educate people on CCOP. You know, there are a lot of residents in the county who don't know that CCOP exists, or if they do, they have a lot of questions about what we do, who we are. And so plans are underway to do more outreach to educate county residents on our role and the complaint process against police officers and the review process after Internal Affairs has completed its investigation. So that is, in a nutshell, a broad overview of CCOP, but I look forward to answering any questions that you all may have.
Thank you for that. presentation. I thought it was great, actually, a lot of information. And thank you for the data. I really appreciate that too. It's been hard trying to get data.
Yeah, absolutely.
So appreciate you sharing that with us. Angela Madsen, you have any questions?
Do you have a budget?
I was going to say question.
We do have a budget, and I am going to hand it over to Ms. Hall to talk a little bit about CCOP's budget.
I was going to ask that same question, Judge. Great question.
Great question. Thank you, ma'am. That was very excellent.
I'm sorry, I was on mute. We do have a budget like any other county agency that is that goes through the regular review process.
Thank you, ma'am.
How much is that budget?
This year is $397,000.
397,000, and the members, the 7 members are part-time?
The 7 members are considered contractual.
Contractual workers. Okay, got it. And the attorney is also contractual?
Also contractual.
All parties within the CCOP are contractual?
Except for the permanent staff.
And how many are those?
2.
2 permanent staff, and along with who conducts the actual investigation? Is that the 2 staff and the attorney? Without that, we know the CCOP is not meeting right now, but who conducts the investigations on behalf of?
We don't do investigations. We review the investigations that are conducted by the police department.
Correct. And that's done by
that is done by the panel.
Okay, thank you, Ms. Hall. Appreciate that. Okay, I saw a couple questions on here. Mr. Ross?
Hello?
Yes, go ahead, Mr. Ross.
Okay, you got a $397,000 budget, and they won't fund the necessary money to do the investigation, or where's the problem in getting the extra money to do a full investigation, what you need?
This year, and maybe even last year, we have not requested that extra money. In the past, it has always been that there wasn't enough money. We have not recently requested it. This year's budget was increased over last year's budget because of IT costs. We're looking at the dollar figure. There's a significant IT cost, and we asked for another person to help us work through a backlog, which is why the number has gone up so significantly from last year to this year. That amount of money pays for the IT costs, the personnel costs, the panel costs, the attorney costs, and all of the other administrative costs for the agency. And the county has been very frugal on its allocation of funds.
But if you can't do investigations because you said you don't have the funds, then how do we get you the fund that you need to do a proper, so you can do the investigations? I'm not understanding.
We would have to do an analysis of whether that would require a full-time investigator or a part-time investigator or contractual investigator. We need to look at that to see just how much. The comment about the investigator has been a long-standing comment since the legislation was passed a while back. We have not recently seen the need for an investigator or tested the investigative capacity. When it was first, when we were first given that authority, we bumped up against the need to have sworn officers. We looked at using the Department of Correction officers for doing that, but we only ran across a few investigations where we actually needed to do that, and not enough to justify adding an investigator to our personnel costs. It's not been an analysis done on that recently.
Okay, I got a couple more questions. I don't want to tie it up. So when a citizen files a complaint, do they file it with your office or do they file it at a local police jurisdiction?
Either. They can file it anywhere.
They can drop the complaint off at our office, but it is not officially filed until it's in the hands of the police department. So we can facilitate the filing of that complaint by receiving a complaint and passing it on to the police department. But the clock ticks when the police department gets it.
Hey, Ms.
Okay,
Hall, Mr. Ross, let me jump in here real quick. Ms. Hall, your phone is, or your device is going in and out, and it's a lot of static, so it's kind of hard to hear. I'm not sure what you can do to fix that technical difficulty, but you're giving us some great answers. So I want everybody to be able to hear what you're saying.
I don't know what to do with that. I haven't. It's been doing that the entire time that I've been listening.
Okay. Well,
is that better? I moved my phone device away.
It's a little better. It's a little better. Mr. Ross, you got one last question?
Yeah, I'm going to drill down on this form being turned in. The form is turned into, the citizen goes to a police station and turn in the form. How do you know that they turned in the form there?
The county legislation requires that they notify us within 24 hours of receiving the complaint or the very next day, the very next business.
Should
So
I think a better process would be that the forms come to you, you get them a reference number, then send them to the police department. It doesn't matter when the clock starts, but we got to get good accountability.
The form comes to us as a courtesy. We send it on, but it is not officially filed until it's in the hands of the police.
I understand that.
So
you can't get a good accountability if you're going to 7 different stations, and we don't know which one may get filed in file 13. Officer may just think, oh well, I just throw it in the trash can. So that there got to be a chain of custody for that form. Once it gets to the internal affairs, then that's when the clock starts ticking. It doesn't matter. It could take a month to get there. At least you know that that file is at the internal affairs.
When they file it with us, we have a log of when we received it and when we sent it and referred it to the police department. And we have a log of when the police department notifies us by case number that they have processed.
Okay, I read all your stuff online. I looked at it very carefully. I had some great concerns about the citizen oversight panel, and that's not really doing what it's supposed to be. It looked like a paper tiger. It's there going through the motion since 1991. We got to put some serious teeth, give you guys the power that you need so that the citizens are satisfied with the results, that we have a true oversight panel. Right now, it's not a true oversight panel. Thank you very much.
Thank you, Mr. Ross. Ms. Mormon?
Yes, thank you so much for the presentation.
Can I at this point just address what he said? I think the kind of changes Mr. Ross wants to see are going to have to be legislative changes.
That's okay. If you need legislative change, then tell us and we can get that for you. But this is not working.
Correct. Okay. Yep. That's what we're here for. It can be legislative changes. It can be internal policy. We can make all the recommendations. We do need the information though, so that we're able to make some clear recommendations. And I thought the presentation highlighted several of those that were challenges. So Ms. Morning, go ahead.
Yes, thank you so much. Okay, first of all, I'd like to know, how are the panel members chosen and what are the qualifications? Because I also see we have a vacancy, and I saw that you said quite a few times you've not had a quorum. So this concerns me, because if you can't get a quorum, then you cannot render a decision. So can you answer those questions for me, please?
The county executive makes the appointments. The county council confirms those appointments. They are working on that vacancy now. The vacancy, the vacancies that occurred last year were due to 2 resignations, not vacancies. The inability to have a quorum was due to 2 resignations, a long-term illness, and a maternity leave. It all came at the same time. So that left us with only 3 members to have. We already had 1 vacancy when that happened. They filled those vacancies, and they were finally filled in November. They filled all of them, and then 1 person resigned almost immediately, leaving that 1 vacancy that they're trying to fill now, which probably would have been filled by now had it not been for the pandemic.
Got it. Thank you very much. Ms. Brewer, I know you're the appointment secretary for the county executive.
Yes, again, I am the boards and appointments, the liaison. And, to be honest, that is a hard panel to fill because these are very hardworking individuals that whether they're meeting weekly as opposed to other boards and commissions that may only meet monthly. So individuals who are interested in being appointed, they send a letter to the county executive. We vet them. We try to make sure that they are as informed as possible, realistically in terms of what the time commitment is. And so it is certainly not the easiest appointment to make. And as was said, we had identified someone for the final seat, and that has since changed. So we are still trying to fill that last vacancy, and the goal was to have it filled before the fall.
Yeah, I heard somebody retired recently, so maybe they might have an opportunity to apply. I'm talking about you.
And if I can just add on to what Ms. Brewer was saying, so for the panel members, we typically meet once a week, but for 4 hours. Like between 6 p.m. and 10 p.m. we're reading and reviewing cases. And because of the backlog, because of the multiple vacancies, I was one of the maternity leave folks. I had my baby, and so I couldn't be on the panel for some time. And then we had at the same time, folks who got sick or left the panel. So in November, we have been, in order to kind of work down the backlog, we've been meeting twice a week for 4 hours in the evening after most people have worked their full-time job during the day. So it's a challenge, but we do what we can to make sure that we stay focused in order to review the records. We have a thorough review process. We have to review all of it. So it's a multifaceted a job being a.
Have we ever thought about having alternates also, just in case this happens, that we just don't go without, but have someone else who can serve, just like we do on jury duty and things like that? Because this panel seems to be a very important element of our community, especially when it comes down to the police department.
I think, number one, that would have to be a legislative change, because the legislation specifically says what the composition of the panel should look like. And if we had an ability to meet virtually, some of those issues would be taken care of in terms of a quorum, except for the vacancy issue. And we've never had an issue like that before, where there were so many vacancies or so many issues at one time. This summer, that was quite unusual.
Yeah, thank you for that, and thank you for the question, Mr. Ivy.
Thank you. I was curious, does all of the information that you get police department, or are there other sources of information that supplement your files?
No, we get the complete file for a case, and so all of the records that Internal Affairs developed in compiling the evidence to create that record, all of the evidence is in that one file, including any audio or video recordings, and that file is sent to CCOP. So there are no supplemental records from any other source outside of what Internal Affairs reviewed and used their recommended disposition.
Okay.
We can get one record in 3 boxes.
Yeah, I follow you.
Not all the time.
Okay, so how often does the panel come out, or the board come out with a position that's different than what the Internal Affairs reached? How many times?
About 25% of the time.
Sorry?
About 25% of the time.
Okay. And so what happens if you come out with a different position?
So we'll send them a degree. Yeah. We'll have a memo that essentially is for my signature, that we for that particular file, we will list the dispositions recommended by Internal Affairs, and we'll list whether or not we agree, we concur, or we disagree. And for the ones where we disagree, we provide a narrative and we explain why we disagree. Like if it was a non-sustained, or if it was an unfounded, we're like, no, the evidence actually shows that in this particular allegation, there was enough evidence to establish that it did in fact occur, was not justifiable, but we're responsible for writing that narrative, because the chief of police, in sending it back, will review it to see whether or not it's probative enough to consider changing the disposition. Because remember, IA, they sent us the recommended dispositions already. And so we have to be able to articulate why that disposition should be changed. So it's up to us. It's incumbent upon the panel members to draft a narrative when we're sending any disagrees. And we don't always disagree. Sometimes there may not necessarily be enough evidence for us to disagree, but we may have some concerns. So we'll add notes about a particular case or a particular allegation.
Can I add one other thing with that, if it's okay? This is Marva Jill Camp.
Yes, real quick, please.
Okay, I was going to say there have been instances where the police department will have charges, and the panel will decide that there were charges missing, and will add those charges to the list and then decide whether it's sustained, non-sustained. So you do have instances where the panel takes a more aggressive role with respect to that. And there are also cases where they might agree but think the training or some policy changes are in order. And so they can make that as a recommendation, even where they agree with the disposition, but may believe that there was enough information that other things should occur, like the training.
Well,
I do. Go ahead.
One last question. How often do you come out with a position where internal affairs has said it's unfounded or not sustained? You think it should have been, and the chief, is it the chief that then makes the decision? How often does that happen per year, where the chief then agrees with your position?
We would have to get that. I don't know, Denise, do you have that on hand? We would have to get that for you, Mr. Ivy, that data, if we can get some data going back a couple of years. And I'll say that, sometimes we're trying to get more information flowing from the department about what happens when CCOP disagrees with cases. So that is, and again, that kind of goes also back to the challenges with our data entry system. It's limited. And so we can't do an analysis. The police department has its own standalone system that we don't want to interface with. We want to have our own, but we can get that data for you. I don't know if you have the 2019 data on that.
And also with the body cam, sometimes we can't look, that we might have to, they'll make a decision, they'll look at the footage and there's not body cam to give that footage. So you can't necessarily disagree because you're missing information that would be necessary in making a disposition.
Say that again. You don't get to look at body cam footage?
So they will get recordings of a particular instance if there's something that can be recorded, but in some instances that information hasn't been recorded. And so where there might be in the record some concern, it can't be validated one way or the other because we're missing the body cam of the recording.
I think Mr. Ivy's question is, does the CCOP have access and can they review body cameras?
We can, but in some instances they're not working. And so those are the instances we're talking about. If it's available, that's part of the record. If it's not available, it's not, and they can't review it.
Let me just ask a quick question. Ms. Lawson, do you have, the CCOP have access to the personnel files, all the files that the Prince George's County Police Department has access to? You have access to them? We do as part of, yeah. And the 30 days that you have to.
Well, we have access to.
I'm sorry, go ahead.
We have access to the part of the personnel record that comes as a part of the file that we get. We don't get the officer's personnel record from personnel.
So they only send, can you clarify that, Ms. Lawson?
Yeah, so we will get, so in a particular, when we talk about personnel files, the CCOP is responsible for reviewing for a particular case. So we will have personnel files associated with that record. So let's say, so for example, we will have the recommended disciplinary action. For some cases, we've actually seen a couple recently. That's something that we hadn't seen before, but that is something that we have access to. So like what Ms. Paul was saying, we don't have like carte blanche access to the entire personnel file, but related to that particular case and any action that may have happened, we have access to those files.
Got it. So you're well, okay. So that answers my question. So would you want more access? Should you have more access in your opinion? To these files?
I think that's a really good question. And so we have to balance, the CCOP's objective review of an individual case, but we also want to be able to have a meaningful review. And again, I keep going back to the data entry limitations that we have. And we go back to that because, if you have a particular officer, because we've noticed some trends based on, I'll just tell you that, we have what we call the report of information, and that's a synopsis of the file. And so we have all of the panel members have a copy of the report of investigation, even though one panel member is assigned to review that case. So if I tend to keep all of the report of investigations, but if we notice that there's a particular officer that has come up multiple times, then we start to put together some trends, but it's hard for us to do that in a meaningful way. We just kind of do it with what we have. So I think that it would be beneficial, especially to identify trends.
Yeah, let me ask a question. Would you consider, let me ask you two last questions, and we're going to move on to Mr. Turner. Would you consider yourself part of the accountability arm of the police department?
An arm of the police department? No.
No, accountability arm.
Yes, yeah, yes, yeah.
Right. Okay, then my next question is, would you consider yourself underfunded as well?
Yes, we are underfunded.
Thank you.
And I know we don't have a lot of time, but I would say that, this is a really important job, but it's like we have a whole bunch of people who are doing it on a part-time basis who are very conscientious, but when you have, and I'll just say, when you have a full-time job, you have a family, and you're going to CCOP reviewing really important records after a long day. And this is, it is how much does the county really want to invest in the CCOP? And so, it boils down to that. So we do the best we can with what we have, but we can have a lot more to have a more meaningful review. I'll stop there.
Thank you for those closing comments. We appreciate that.
Can I add something to that? I think we're more underpowered than underfunded.
Okay. I think money comes with.
If you add more power, of course, you'll need more money, but currently we're underpowered.
Ms. Hall, I want to thank you very much for your time. We're gonna have to move on, but I think that, from what we've seen so far, we believe that more money could come, and then more access to accountability measures and more access to information is necessary for the CCOP. So we'll move on to our next.
And changing the legislation to make it a little bit more powerful.
Thank you, Ms. Hall. Thank you, Ms. Hall. We appreciate that. Thank you. So we'll move on to the next presentation. We have we have Mr. Turner here from the Office of the Inspector General. Is it Inspectors General or is it Inspector General?
It's the Office of the Inspector General.
Okay, yeah. Some call them Inspectors General too. So, all right, sir. Thank you very much.
Thank you all. Appreciate it. Thank you, Delegate Washington and Co-Chair Judge Lemazny. I appreciate you all giving me the opportunity. So let me start by saying that I've been in this position as the Inspector General for the Police Department since December 2018. So it's been a little over a year and a half now. I'm the third Inspector General since the position was created a little over a decade ago. My predecessor hit the position in, I believe it was January, February of 2019. So I'm sorry, of 2018. So I came on in December 2018. So the position was open it was vacant for close to a year before I came on. So next slide, please. This is the organizational chart. You'll see the Office of the Inspector General down to the left, towards the bottom. And you'll see that there are a couple of units that I am responsible for. The first one says accreditation. This is my understanding is this is an older. It's actually the most recent org chart we have, but it's not up to date. So the accreditation refers to CALEA accreditation. That's no longer applicable. We are the Prince George's Police Department is not CALEA accredited. So and it was not when I arrived. And then I also work with the Administrative Hearing Board. And I'll talk about that a little bit. And I also work directly and oversee the Planning and Research Division. I want to give recognition to one of the employees who works in the Planning and Research Division. She's on. I noticed that she was on this meeting, Tammy McGuire. So I just want to thank her for being on this meeting. And I may have to refer to her if there are any specific questions with regard to Planning and Research Division. Okay, next slide, please. Okay, so the Office of the Inspector General serves as an independent and objective investigative and inspection body to promote economy, efficiency, and effectiveness in the administration of the police department's operations and programs. It upholds the department's public safety mission that's based on constitutional policing. Okay, essentially the goals of the Office of the Inspector General are to prevent and detect waste, fraud, abuse, mismanagement, and wrongdoing within the police department. Next slide. In order to achieve these goals, the Office of the Inspector General handles certain external as well as internal complaints that are lodged against sworn and unsworn employees. Sworn employees, meaning police officers, of course, collaborates with the Internal Affairs Division regarding discipline oversight. Again, I mentioned earlier that I oversee the Administrative Hearing Board regarding disciplinary hearings. And I also spend a good deal of time collaborating with the Bureau of Administration, with all of the bureaus. There are 4 bureaus within the department, but particularly I work frequently with the Bureau of Administration of Homeland Security, which is responsible for training and education. Next slide. I also work occasionally, not often, with fiscal management to resolve financial issues. Now, and I want to make it clear that there are the county conducts financial audits of the department, but occasionally I will be asked to take a look at issues that arise from time to time regarding disputes or some type of issue that comes up with regard to finances, including expenditure of funds allocated for specific purposes, and also recovery of monies. If there's a dispute between the police department and current or former employees with regard to money allegedly owed to the department. I also, again, according as I mentioned from the org chart, I oversee the Planning and Research Division, which is responsible for evaluating the department's policies and procedures and determining and implementing best practices. In addition, Planning and Research works with higher education institutions and research organizations to conduct studies that help to advance the law enforcement profession. Okay. And then finally, I work closely with the Office of the Chief regarding various projects and initiatives and provide legal guidance to the entire executive team. And when I say executive team, I mean the Chief of Police, the Assistant Chief, the Deputy Chiefs of Police, and also the Chief of Staff for the Chief. Next slide, please. So I'm just going to go back over in a little more detail what I've already gone over. So my work with the Internal Affairs Division, routinely I'm asked to review case files and evidence from investigations that Internal Affairs conduct. I am asked to provide legal insight and recommendations with regard that go to the sufficiency of the evidence, as well as potential administrative charges against officers. So I guess you could say that in some what I do on the, I tend to do on the front end what CCOP does on the back end. So CCOP looks at the charges that were brought and that were adjudicated. Sometimes I'm asked to look at those charges on the front end. Now, again, I'm not asked to look at every single case that's investigated and by the Internal Affairs Division. There are hundreds. And so that would be an impossibility for me to do that. But from time to time, I'm asked to look at those files, or I'm asked to sit down with the leadership of the Internal Affairs Division, and we'll talk about cases, and they'll show me evidence and ask me my thoughts on it. So that's essentially the way that works. Sometimes I'll draft something in writing and I'll give them my opinion in writing. So that's generally the interaction between myself and Internal Affairs. The purpose for doing this is to ensure fairness and equity in the administration of the disciplinary action that's instituted against the officers. And also, as the Inspector General, it gives me an opportunity to provide greater insight into whether the department's policies and procedures, which include its general orders, are appropriate or whether they should be modified. I guess I tend to look at my job as sort of from 30,000 feet. So in other words, I look at cases, I look at a lot of different issues, a lot of things are presented to me. And as I'm looking at these things, and as I'm from time to time providing guidance to officers with regard to these issues, I'm always thinking, how does this impact the department as a whole? What are the best practices that exist with regard to these particular issues? Should we make any modifications to the general orders or to our policies and procedures, or operationally that would ensure that we're accomplishing our mission and that we're also engaged in constitutional policing. Also, I just wanted to point out, and I've said it already, I don't conduct, this is a question that was posed last week, I do not conduct any auditing of internal affairs cases. CCOP, and I understand that there have been challenges from them, but if I were to engage in that, I would be essentially stepping on their toes, and that would not be that wouldn't be very feasible. So, next slide, please. With regard to again, the Administrative Hearing Board is one of the units essentially that falls under the Office of the Inspector General. So just to be clear, under LEOBR, officers who've been charged with disciplinary action, they could, and we've talked about this, but they can elect to have a trial board. Depending on what those charges are, the board will consist of 1 or 3 members. Okay, there are within Prince George's Police Department, there are 2 permanent hearing board co-chairs, a major and a captain. Those are permanent, again, co-chairs. The third is an officer of what's called equal rank, and that person is selected by the chief and the officer who's charged administratively with the offense. My involvement or my role with regard to administrative hearing boards is that I oversee the hearing by providing legal guidance when asked to do so by the hearing board members during the hearing. To sort of frame this, board members are essentially, you should think of them as judges, okay? They're not attorneys. And although the way that they preside over the hearings there's some similarity to a trial, my role, or I think my value in that scenario, is that I can provide some legal guidance to these officers when they are making decisions. You've got attorneys in the room who are arguing the case, who are presenting their cases, and sometimes they have to essentially make legal rulings, just like a trial. And so sometimes they will ask me questions about, I'll get questions about admissibility of evidence, or about things like whether hearsay is admitted, that sort of thing. So that's how I play a role in that process. Okay. I do not have any involvement whatsoever in the deliberations or the recommended punishment. That's all the decision making that the board members conduct. And but I will, after the hearing is over, after there's a decision, I will sit down with the permanent board members, and I will conduct a post-hearing debriefing, in order to give them some pointers, or to answer any questions they may have, to help them to be better prepared for the next hearing. Next slide. PRD oversight, or Planning and Research Division oversight. I spent a lot of time focusing on ensuring that we have appropriate procedures within the police department. Some of the policies that and general orders that I've worked on in the year and a half, this is just a few, but these are, I guess, some of the ones that sort of stick out for me. The immigration policy, about a year ago, the county executive made a decision for the county with respect to the county's position on whether, with regard to assisting federal law enforcement with federal immigration officials with their immigration enforcement. And based on that, we modified our immigration policy that was consistent with the county executive's position. So I worked on that. Also last year, I drafted and we put in place a new social media policy. And that was based on a couple of things. One factor had to do with a case that was decided actually a couple of years ago by the Fourth Circuit. And I had an opportunity to look at that case. And then and I went back and looked at our social media policy. And I thought that to me, it didn't appear that it was constitutionally sound. So I started drafting a new social media policy. The other thing that was going on with regard to social media was that I think this happened either last year or 2018. There was an organization, I can't remember the name of it, decided to look at officers' social media accounts throughout the country. And I believe that organization found maybe it was about 8 police departments, and looked at those officers' social media accounts and found some very troubling things that were posted on their accounts, and so published the information that was in those accounts. And a lot of officers from these police departments, including Philadelphia, San Antonio, I think was another one. A lot of officers were fired or suspended. So that was the other catalyst for me to take a look at our social media policy, to make sure that we were, if an officer was posting something similar to what these officers around the country were posting, we were able to capture that and punish them accordingly if appropriate. So the incentive program prohibition policy was something that I drafted after I actually received a complaint from a citizen. It was an email. Actually, I believe the complaint initially went to the county executive's office, which was forwarded to myself. And I see Chris Marsh is mentioning the Plain View Project was that organization I mentioned with regard to social media. But I received from the county executive's office a letter from a citizen who had become aware that the police essentially had one of the districts had a quota system that was in place and was implementing, and officers essentially were incentivized by making if they made traffic stops and also field stops, they received comp time as incentives. And so once I became aware of that, I made the chief aware of it, and then we addressed it from a disciplinary standpoint. But I also drafted some language, a new incentive program prohibition policy, which was implemented at that time. We can go to the next slide. Okay, again, training oversight. I work very closely with our Bureau of Administration with regard to making recommendations, making changes or making recommendations in terms of our training curriculum in order to ensure best practices. A couple of things that I've been working on for some time actually, and has come up during the course of these discussions that we've had about police reform, duty to intervene. Of course, the George Floyd case was an example of where officers failed to intervene, and if they had done so, they would have saved his life. And so that's something I've been looking at since last year, actually. Matter of fact, in September, myself and Deputy Chief Harbin traveled to New Orleans, and we attended a training down there that the New Orleans Police Department put on, and they have a what they call bystander intervention training. It's a program called EPIC, which stands for Ethical Policing is Courageous. And so they've had that program in place for quite some time now. We have aspects of that program already utilized within our training, but I've been advocating that we sort of we expand it and make our bystander intervention training more robust. Also, crisis intervention teams. I've spent a lot of time advocating, doing research and advocating for a more, I guess, a more dedicated crisis intervention team, a unit. We have officers who've been trained in crisis intervention, but we don't actually have a team of officers that will respond to calls. They're not first responders. And they may show up after or sometime later, days later, regarding incidents, but they're not first responders. And so I've been advocating for that as well. I have conducted several trainings for our training for the department. I've conducted training, this is in-service training, and also for supervisors. I've conducted training on ethics and also social media usage. And also, I also provide written legal guidance to the department regarding appellate decisions that are handed down by the courts, and also, and I'm also responsible for coordinating what we call executive review panels. So those are basically panels that are assembled to sort of dissect critical incidents that have occurred in the with regard to the police department. Those executive review panels are crucial as far as I'm concerned, and as far as the department is concerned, because it gives the department, it's a great training opportunity, and it also gives the department an opportunity to really look at its policies and procedures, look at best practices to determine whether or not, whether we have the right policies in place, and also whether the officers are properly executing them. Next slide.
Turner, let me hop in here real quick. I know you have 2 more slides left. We're getting to the 15-minute mark here.
Yeah, Delegate Washington, I can stop here and I can just take questions.
No, you keep going. You have some other slides in here that I thought were really good too.
Okay, yeah. I'll get through those very quickly then. So again, I work very closely with the chief and with his executive team. These are just examples of some of the things that I do. I would say that these are responsibilities that I've been asked to take on that are not really traditional to the IG position, but given my what's been asked of me, my role in my proximity to the chief's office, these are a number of examples of things that I do that sort of are tangential to my role as a traditional inspector general. The next slide, please. And then this is the last slide, I believe. Again, these are just some additional responsibilities. I am in regular contact with with Judge Hall Johnson. I serve as a point of contact for the police department regarding issues arising in the courtroom pertaining to officers. And also I act as a liaison between the department and the state's attorney's office on a variety of issues that come up between the department and the office. And that's it. And I'm ready to take any questions anyone may have.
Thanks. We're going to go to Delegate Fisher for a question first.
Hi, Mr. Chair. Thank you. Hi, Mr. Turner. How are you?
Well, how are you, Ms. Fisher?
Good, good. I have a couple of questions for you, as you know me well. Let me see. I took a lot of notes, so let me just focus my questions. I'll actually start at the end. So with the executive review panels, I'm just a little bit confused about who exactly creates them and how are they different than other reviews, and how do they then make the department more accountable?
Sure. So, excuse me. Well, first of all, the executive review panel is it's delineated in the general orders. So there's a provision in the general orders that essentially that lay out the conducting of executive review panels. The executive review panel will consist of the chief's office, the chief of police, if he decides to attend, the assistant chief of police, the deputies, if they elect to attend. Usually the deputy who's directly involved in the incident will be a part of that panel. The Internal Affairs Division is mainly responsible for presenting to the group. The Training and Education Division will participate in the panel. So basically, I'll give you a quick example, right? We've talked about the Shan case a number of times. So we have arranged to have an executive review panel for the Shan case. That was the case in which the gentleman was shot and killed in Hyattsville, I believe. the training and the training division will attend because they will offer their input with regard to the actions that were taken by the police officers, and they will critique essentially what those officers did. They will make recommendations to the group in terms of if they believe that the officers did something that is that's deficient in terms of what they were supposed to do, and at the end of this ERP, there's usually a written report that's generated. The Office of the Inspector General is responsible for that, so I'll usually have someone draft that, and I'll review it, and I'll finalize it and present it to the chief. Usually, it'll contain recommendations in terms of training.
And there's no citizen on that versus.
Well, no, that's not true. Actually, the police department, the chief, the previous chief, usually did invite several members from the public. I believe that Mr. Ross, who's I believe on this call, he's been invited in the past. In fact, we actually had the Shane case was scheduled, but Mr. Ross we found out at the last minute. We had actually started, we were about to start the ERP. We found out Mr. Ross was unavailable, so we postponed it. So he's been invited. Also, Dr. Marsh has been invited to be present.
Okay. And then the other part, and I have like a million questions, so I'll ask one more and then I'll let the chair figure out what he wants to do. So I think for me, and I don't want to put your job in like layman's terms, but I'm going to a little bit just to ask my question. It almost feels like you're in-house counsel for the police department, basically. And that's just what I got out of knowing what you did before and your presentation. So being in-house counsel, you're giving the best advice for your client, which to me kind of seems like it's the police department. And so my issue and something I struggle with is we all probably can sit in a room and come up with great protocols when someone is shot and killed. A huge thing that I want to see us do is to prevent that shooting and that person being killed, right? We can always do accountability after there's a dead body, but I want there not to be one. And something that I have a huge issue with is the amount of sustained, unsustained, unfounded, purple, blue, whatever complaints an officer has. When does that trigger maybe your role, or what do you think would be the appropriate trigger to then have us investigate that officer, right? Whether it's Corporal Owens, all these things that come out, all these officers have 15, 17 complaints. I don't care if all your complaints are unsustained. The fact that you're getting complaints, and no offense, we all know that they're unsustained, because who's determining whether it's sustained or unfounded? That's like another conversation piece. But even if they are all unsustained and you're good as whoever the officer is, like, how does that then, you have 17 complaints against you, trigger a full investigation, trigger you to, be retrained, and that the public actually knows that, or somebody in the public, I don't know, but like, where is that happening with your role? Can it happen with your role? And what do you recommend us as a group to find ways? Because it's so easy to put the accountability when someone's dead or someone has a serious bodily injury. I want the accountability before that happens.
Sure. Well, first, let me say that that I am not the in-house counsel for the police department. Again, I do provide guidance to the police department or legal guidance on a variety of issues, but it's, make no mistake.
To give you a label.
No, that's okay.
My brain.
No, that's fine. No, but the attorney for the county, as Ms. Weaver stated, is the county attorney. And in fact, I've met with Ms. Weaver. We actually we speak on a regular basis and we work together. I also work with Jack Mitchell, who's the resident county attorney here at the police department. So actually, I think we work very well together, and I don't misunderstand my role here. I do draw from my experience, and I'm asked to draw from my experience a good deal as a former prosecutor with this, particularly not just prosecutor, but the prosecutor with the state's attorney's office. I do have relationships with people in that office. I also have relationships with judges. I think that serve me well here and serve the police department well to assist them as they navigate through all of those things.
Mr. Turner, let me hop in here. I think just because we're at time, we're over the 7 o'clock mark and we're getting to the 7:30 mark. I think her question can you answer her question directly that she asked about when is it?
I was getting to the second. I thought she had a two-part question. So to answer the second question now, my understanding, my recollection is that Major McCreary actually did address what the second question that you had, which has to do with triggering when officers have engaged and have been, I guess, charged on multiple occasions with misconduct, and whether there are any triggering mechanisms that are in place. So he talked about that when he presented. I do agree with you. So to answer the other part of your question, I don't generally play a role in that. Now, if I thought that the system that was in place, which Major McCreary talked about, was insufficient, then that is something I would look into, and I would research it and I would make a recommendation. But I think, and I've had many discussions with Major McCreary about the system that we have in place, right? So I think it's a system that works. Or in fact, it's a new system. So we'll see how well it works. But the last thing I'll say to that is, I don't disagree with you that if you have an officer who's been charged, multiple times and his charges have been non-sustained, those charges have been non-sustained, that still is an alarm that's going off, right? And so I don't disagree at all that there needs to be something in place. And I'm not saying there isn't anything in place, because knowing, having had an opportunity to work with the leadership with the police department, I do think that the leadership would step in and they would address it, and they would notice that, because we've had those discussions before about officers, right? Who've had multiple charges, not 17, but who've had several charges. And those officers, they stand out. So we've had those discussions. But I don't think, I agree with you wholeheartedly that there needs to be a fix. So whether it's legislation or something else, you and I are on the same page with that. So
we're going to go to Judge Lamazny.
What happened to our CALEA accreditation, Mr. Turner? Why don't we have that?
So Judge, I must be honest, I'm not exactly sure, because again, this preceded me. My understanding is that at one time we did have CALEA accreditation, and it was, it expired, and the police department, for reasons I don't know, declined to. In fact, my understanding is that at one point, the previous chief of police had made the decision to sort of re-up, if you will, with regard to accreditation, but it didn't happen. I don't know the reason why that did not happen. In fact, I've come across paperwork, documentation, and I've seen the exchange of the conversations that went back and forth on that issue, but it sort of went away, and I didn't see how that whole thing concluded. So I just know it doesn't exist anymore.
Is it important to have that accreditation?
I think that there are other, the police department, of course, is MPCTC certified. I think that even though the police department is not accredited, we do adhere to the policies and procedures and the best practices that are laid out with CALEA accreditation. So I'm not sure if for as a practical matter that it makes much difference. So I've not seen where it has negatively impacted the department.
Thank you. Thank you.
Thank you. Okay, we're gonna go to Miss Josephine Morning.
Yes, I'm sorry, I'm not trying to dominate these meetings, but I have two questions. When you got to the slide that had something about the body-worn camera policy, we didn't get to that part at all. It's sort of like that was skirted past. So I want to know about the body-worn camera policy and the crisis intervention team. You said they're not considered considered the first responders, but they should be, because if we have a situation where we have a person that we feel the crisis intervention team should be there, I think they should be called first also along with the police department. So could you explain to us about the body worn camera policy and the crisis intervention team?
Sure. So with regard to the body worn camera policy, they're currently.
Can I ask a question? Can you do that in a minute and a half? Because that policy sounds like a very long policy, and then the other one also sounds like a long policy too. All right,
I'll
can we get something in writing on that? I mean, sure. Can you provide us with something on what the policies are for the body worn camera?
Well, sure, I can certainly provide that to the committee. The body, so we're essentially updating the body worn camera policy. There is a policy in place. It's not what we refer to as a general order. It's what we call a chief's order. And the reason why it's not sort of in that sort of posture as a general order, because up until very recently, the body worn cameras were part of a pilot program. And so now that we are outfitting more officers with body worn cameras, we decided that we were going to actually put out so in other words, the chief's order was only distributed to those officers who were wearing the body worn cameras. So that was probably about 80 officers or so. By the end of the year, our goal is to have roughly 1,000 officers, all the patrol officers, not quite 1,000, outfitted with body worn cameras. So it will be transformed into a general order. I'm working on making some changes. Myself and others are working on making changes to that general order to make sure it fits with technology and it's consistent with other policies. So that's the case with regard to body cameras. And then the other question, I'm sorry, was
crisis intervention.
The crisis intervention. So what I've learned is that first, with regard to this police department, again, we have officers who've been trained in crisis intervention, brand new cadets who are going through the academy are given some training, and then a number of officers on the department are actually certified in crisis intervention, but they don't make up any. So they're spread out throughout the department, but they don't comprise a particular unit or units. What I found is that there are police departments around the country that have crisis intervention dedicated crisis intervention teams, and those crisis intervention teams actually they act as first responders to calls for service. Very often when it's known that citizens, that there are mental health issues involved with those citizens, and so we don't have that. And so what I've been advocating for is that the department implements or assembles a crisis intervention unit that takes on that structure.
Thank you.
Sure.
We need that. Yes, we do.
Absolutely. Thank you, Ms. Morning. Mr. Ivy?
Well, in the interest of time, I'll frame it as an information request.
Take your time, man. We got all the time in the world. Go ahead.
Well, I appreciate it. But just to sort of tie into an earlier conversation about the number of times that the department provides information to the state's attorney's office about, for example, officers who have been in trouble with respect to lying, or there's some Brady information in their file. Sure. And I think the number was 5 or 6, where it ended up getting to the point of an in-camera review. I noticed in your presentation that you're part of the hearing board, or you observe them or involved with them in some way. How many hearing board reviews, if this goes through there? And I also noted that you had a false statement document that you worked on, I guess a general order. Sure. How often are officers found to have made false statements or, untrustworthy or dishonest statements? And you might have to get data for us on this, but how does that stack up with the 5 or 6 that had in-camera reviews? And then the other question would be, is there some kind of mechanism where when a hearing board makes a finding that's negative and would clearly fall into a Brady category, is there a way that information is automatically provided to Mr. Mitchell, Ms. Weaver, the state's attorney's office, so we don't have this disconnect where I think what I'm hearing, there's Brady information in these police files that's not getting to the state's attorney's office and therefore not to defense counsel?
Good evening, Mr. Ivey. It's good to see you. So I think there's a piece that's been missing from the conversation up until this point, and you actually touched on it. The relationship between the state's attorney's office and the police department is this, and this goes back to when I was with the state's attorney's office, going back to 2012. Okay, with regard to any sustained findings made by the police department, okay, these are administrative hearings. Any sustained findings that tend to bear on an officer's credibility, that information is directly provided to the state's attorney's office. That's how the state's attorney's office puts together their flagged officer list. Okay, we used to keep that list. I used to, when I was the deputy state's attorney and then the principal deputy, I oversaw the unit that was responsible for compiling that list. Okay, so that information that's done by agreement. So it's very possible that the reason why there are only 5 or 6 cases is because that system has worked up until this point, and there are only a few cases that may not quite fall into that category. But anytime there's been a sustained finding by the police department with regard to, let's say, false statement, misrepresentation of fact, it could be theft, anything that potentially bears on, any potential Brady, as we know it, right? Potential impeachment information. That information is provided by the police department to the state's attorney's office, which then keeps that list that we talked about.
So how many officers, let's say over the past 5 years, have been found, their findings have been sustained with respect to honesty or truthfulness, and that information was relayed to the state's attorney's office?
So when I was with the state's attorney's office, I apologize. I never counted the list. One of our attorneys, one of our supervisors, was responsible for keeping the numbers. But since I have come here to the police department and become the inspector general, I've actually asked we've had conversations with the state's attorney's office, and we've asked them to provide us with that list with the number of officers that are on the list that they've compiled, because it's a list that is it's a rolling list. So officers who were put on the list, years ago could still be on that flagged officer list. So we asked the state's attorney's office to provide us with those numbers, and in my opinion, they didn't do a very good job of providing us with the list, or at least it took them quite some time to do so. And based on the information they provided, I'm not sure if that list is accurate. I don't know why the police department doesn't keep the list. All I can tell you is that there's no requirement that the police department keeps the list. LEOBR actually talks about police departments keeping essentially a list like the one we're talking about. And all it says about that is if the police department is to keep a flagged officer list, right, that they are, that the police department is prohibited from disciplining those officers from being on the list. So that's all LEOBR has to say about that. But it's much more important that the state's attorney's office, and I'm sure Mr. Lottridge will agree with this, it's much more important that the state's attorney's office keeps that list than it is for the police department to keep a list that they're actually providing to the state's attorney's office.
I'll stop there. Thank you.
Some heavy information there, man. Tell you woke up Mr. Lottridge out here.
I saw him falling asleep. I figured
Miss Danza, I know you have a question.
I do, and I think he woke up Mr. Lottridge and probably Miss Joy. I'm sure that she has a comment as a follow-up to much of what Mr. Turner has stated as well. And so my question, Mr. Turner, is really more so about the findings and recommendations on the several areas within your purview as IG that are provided to the department. Is there a comprehensive report, whether a quarterly or annual report of some sort, that is available for public consumption? I think it's just important for obviously the public to be aware of what, those findings and recommendations actually are, and moreover, their effectiveness and whether the department is actually following them. So is there some sort of a report that you produce with respect to those findings and recommendations?
I do not provide a public report. No, I don't. The reports that I provide are internal documents. I don't disagree. And matter of fact, I think what I've found is that many IG offices do generate reports that are made public. That's not my mandate. I've not been required to do that, but I wouldn't be opposed to doing it.
Thank you.
Can I follow up on that and just ask, where do you get your mandate from? Where is your position in statute? From my understanding, was because of a consent decree, or where is that within the chief's order, or where is it? Where's your position outlined?
So the IG position is noted in there's actually a general order that identifies the IG position. There's no legislative mandate for the IG position. Again, that's something that, I believe that, well, first of all, let me say this. The Inspector General position is not a position that's very old, it's not been around for a very long time. If you look at, for instance, the Department of Justice, their Inspector General has only been in existence for about 30 years now, okay, which isn't very long. So the idea of an IG is I think relatively new. Also, with regard to IGs employed by police departments, there are very, very few around the country. I'm aware of just a couple. New York has one, for instance, and LA has an IG's office, and those offices are much bigger. Now they have many more officers than we do, but it's much bigger. Those officers are much bigger than my office. I'm the lone person with
You're just by yourself, correct? You're just you.
Yes. But I have had conversations, Delegate Washington. I have had conversations with the chief and also with others in terms of the IG position, not just within the police department, but also creating an IG position for the county. Montgomery County, for instance, has an IG for the entire county. Baltimore City has one.
I've been the lead on Inspector Generals. Mr. Ross knows that for a long time in the state and through education too. So, Mr. Ross, with that said, I apologize for skipping you, but you can go ahead and ask your question now. And then we're going to go to Miss Renee Joy, and then
I have one question and one comment. you said that you do a debriefing of the two lieutenants, but not the officer with the same rank. Is there a reason for that?
Well, not really. Only, I guess, only that certainly if that third person was interested in sitting down and talking about it, I'd be happy to do that. But and this is just been in practice. The reason I focused on the permanent board members is because they will be, they'll be called upon to conduct other hearings, and so that third person isn't necessarily going to be selected anytime soon to participate. But certainly, if that individual, and I appreciate you mentioning that, so I'll certainly reach out to that third person the next time. And I'll say this just as an aside, what I've observed and what I've experienced is usually that third person, they're not really happy participants oftentimes. So I'm more happy to extend an invitation to them.
And then the clear certification. I was very disappointed when I heard that they didn't have the clear certification, but that's the opportunity that the community gets to have some input. I'm called on several jurisdictions to report or give my feelings about the police. And we take it very seriously at the NAACP. We sort of look at what occurred over the course of a year before we bow ahead. So I'd like to see the department go back to the clear certification. But just briefly say what the clear certification is, because a lot of folks may not know.
Well, I'm not particularly versed on it because we're not certified. We're not clear accredited. So
we do have, just to answer that, we do have, the Greenbelt Police Department is a kilo, whatever, however you say it, is certified. And so we can have them come in and give a presentation on something like that, and be able to provide information on what that looks like. I have done some research on it. I've done some research on it, and it's okay. It's not the greatest thing in the world, but I'll say it's okay. But we're gonna go to two more questions, and then we're gonna stop there. Miss Joy.
Thank you. I just wanted to clarify just a couple of things that you addressed, Donnell. With regards to the police department turning over sustained findings that go to the officer's credibility, I think that, I recognize and understand that the prior administration had kept a database of individuals that were that had discovery issues that we were regularly turning over to Defense Counsel. We have that flag database is still maintained, and it's in its same form under as when you were in the office. And what I have to say is that I'm finding that through this new review process that we have set up with the police department is that we are indeed learning that is not indeed the case, that all sustained findings that go to the officer's credibility have been turned over, and the police department is adequately or has been adequately updating our office. So that's why I think, what this new process that we have going with the county attorney's office has uncovered is that there is a great need for that and for us to be able to access this information, because that has not been the case entirely over the past several years. So, I think that it kind of needs to be talked about a little bit more, because and there has to be a new system where we are communicating more with internal affairs, because we're just finding that there are things that have not been turned over to us over the years that are discoverable, and we are now in a position to turn over. So, and I would be more than happy to speak with you, also offline, if you are unhappy with the information that I gave the Internal Affairs Department about our flagged officer list when it comes to the Prince George's County Police Department. You know, we have to keep records not only of Prince George's County Police, but of all the other municipalities that are within the county. And, you know, with regards to the information that was given back to the police department upon request, we just handled that information that was with regards to the Prince George's County Police Department. But I would be more than happy to speak with you about anything that you thought was insufficient about the information that I provided. And I just wanted to throw that in there. And I also, you know, I put in the comment section the law enforcement, and if anyone wants to take a look at it, the LEOBR article that deals with the list that the LEOBR, I guess, permits the police department to maintain if they wish. So I just wanted to, you know, clarify that with you, and I'd be more than happy to discuss that further about information that you are saying that we haven't been given. But I do want to make sure that we get all of that discoverable information, and that's why we're so interested in getting more access to these files and working up with an MOU with the police department in order to ensure that we get all this information. So I just wanted to clear that up. So thank you.
Thank you. Looks like we have a lot. Looks like we got a lot of work to do, and we appreciate those comments. Mr. Lockridge.
I know it's late. I just want to follow up very quickly on Mr. Ivy's question. Would it be possible for us to get without names or even potential findings, the number of officers who are found to have committed impeachable acts over the last 2 years? Because if we can compare that number to the number where there's been in-camera reviews and some other things, we might start to get a sense of what has actually been produced versus what should have been produced.
I think.
Sure. And how far would you like me to go back?
As far as you can, but I'd ask for 2 years. But if you want to go further, I'm pretty sure everybody here is all in on going further.
I'm gonna stick to the 5 to 10 years that we've been asking for everybody. So if you can give that information, that'd be great. Mr. Turner, you have any closing comments? I want to thank you first and foremost for your presentation today.
Again, I just want to thank you all for the co-chairs for giving me the opportunity to speak to the group. And if anyone has any follow-up questions, I'm happy to answer them for you and provide you with any additional information.
Yeah, I think there's a lot, and I think there was a lot of great questions asked today. And I think we talked a lot about accountability within our police department today and what we can do to increase that accountability. And, you know, what I'm going to ask Miss Lieutenant Harvin, if you can, you know, for our next week's meeting, we're going to have the chief back or someone from the police department back about the data that we have seemed to be not receiving in some of these presentations from the department, just so that we all have a good snapshot of a good idea of what's really happening in numbers. So I think all day today people have been asking for those numbers. So next week we're gonna, if we can ask the chief or his representative to focus on the numbers for us and the data collection and what's not being collected and what could be collected. Things of that nature, so that we can make recommendations on what should be collected and what shouldn't be collected, will be helpful for us. Judge Lamasley, you have any comments?
I thought all of the presenters were very impressive. This was very, very good.
Yeah. Thank you, everyone. Any closing comments? And I know the chairs wanted to hold back, but I think some of the chairs had to hop off, Chris. So maybe we can do it another time. But any other closing comments from anybody else? Ms. Weaver, thank you so much for being here.
Thank you.
We appreciate you, and thanks for staying this entire time. We appreciate it, and we look forward to your data next week too. If it takes another week, that's fine too.
I'll make sure I definitely keep in contact with you. If I can't have it, I'll give you a status.
Great, we appreciate
my calendar.
Okay, great. Thank you very much. Thank you, everybody. Have a good night.
Thank you, everybody.
Good night.
Thank you.
Good night, everyone.
Good night.